ever signed on the dotted line, and then maybe somewhere down the road you start wondering, how exactly does this thing end?
Mm-hmm.
Or maybe you've felt a bit stuck in an agreement, one that just seemed like it would go on forever. You're definitely not alone there.
Right.
Today on the deep dive, we're uh, grabbing our metaphorical legal machete, I guess you could say,
Yeah.
and we're hacking through the undergrowth of contractual obligations.
Yeah.
You want to see all the ways they can legally come to a close.
Yeah. Think of it like a roadmap.
Exactly.
Right.
Your survival guide to the lifespan of any deal, big or small.
That's right. We've been looking at a really detailed source, basically an explanation outlining all the different legal ways, the mechanisms for ending these obligations.
So it's like having a blueprint, showing every possible off-ramp from that contract highway.
Pretty much, yeah. A comprehensive blueprint.
And by the time we're done exploring this, you, listening,
Yeah.
should have a much clearer picture of how those contractual duties get extinguished. This isn't just, dusty old law books.
No, not at all.
It's practical stuff. It impacts everything, from your, say, online subscriptions right through to your employment contract.
Definitely.
And get ready for some, maybe, light bulb moments, because there are some surprisingly clear-cut ways these commitments can be finished.
Yeah, our goal today is pretty straightforward, really. We want to pull out the essential knowledge from this deep dive into the source material and give you a clear and hopefully engaging picture of how obligations end. We want to equip you with this understanding, but, without getting totally lost in legal jargon.
Okay, perfect. So let's dive in. What about the most intuitive way an obligation wraps up? The source calls it termination by performance. What does that actually look like?
Well, fundamentally, it just means the person who is obligated to do something,
Hmm.
the debtor, has fully and correctly done what they promised.
Fully incorrectly.
Yes, exactly. It's not just about making an effort or getting close. It's about ticking every single box, meeting all the conditions laid out in the agreement.
Like finally assembling that flat pack furniture and realizing, hey, no screws left over.
Ha! Precisely. You've actually done it right.
Got it. So close enough isn't good enough then. If someone, say, delivers only half the goods ordered or the service provided is full of errors,
Yeah,
the obligation just hangs around.
exactly. That kind of incomplete or flawed performance, it doesn't bring the obligation to an end. Nope.
So what happens?
Well, if the creditor, the person owed, reasonably rejects that substandard work or delivery,
Okay.
then the debtor is still on the hook. They remain responsible for fulfilling their original promise and fulfilling it properly this time.
Right. Now, what if the person who is owed the performance is actually willing to accept something different? The source mentions this Latin term, datio in salutem. What's the plain English version?
Yeah, it sounds fancy. But it's basically like saying payment in kind or accepting a replacement performance.
Okay.
It happens when the creditor agrees, okay, I'll take this different thing instead of what you originally owed me, and that satisfies the obligation.
Ah.
But, and this is a crucial point, there's a catch. If that substitute performance also turns out to be faulty,
Oh.
the creditor isn't stuck. They can actually go back and demand the original performance, or they can sue for the defects in the new substitute thing they accepted.
Ah. Okay. So it gives flexibility but still protects the creditor.
Exactly. It ensures the substitute is actually up to scratch. Otherwise, you could just offer rubbish alternatives to get out of what you really promised. The original obligation can sort of revive.
That makes perfect sense. It's like saying, okay, I'll take this chair instead of the table I ordered. But if the chair leg falls off immediately, you haven't really been satisfied, have you?
Right. You haven't received proper value. Now, about who has to do the performing, does it always have to be the original person who agreed?
Good question.
Well, generally, yes. The debtor, the one who made the promise, is expected to be the one to fulfill it.
Mm.
However, the source does point out that a third party can sometimes step in and perform on their behalf,
Oh, interesting. Under what conditions?
as long as two things are met. First, it doesn't negatively impact the creditor in some way. And second, it's clear that the third party is doing it specifically to settle the debtor's obligation. They intend to discharge the debt.
Okay, so hypothetically, if I owe my landlord rent, could my friend just pay it for me and that settles my obligation?
In most standard payment situations like rent,
Yeah.
yes, absolutely. Assuming your friend clearly intends to pay your rent, not just give the landlord money for no reason.
Right.
And it doesn't somehow prejudice the landlord, which is, pretty unlikely with a simple payment.
Okay.
But there's a really interesting exception. It's called delectus personae.
Delectus personae.
Yeah. It applies when the specific identity or the unique skills of the person who is supposed to perform were a key reason for making the contract in the first place.
Ah, like hiring a specific artist.
Exactly. Think about commissioning a famous portrait painter. You wouldn't be obligated to accept a portrait painted by their apprentice, even if the apprentice is quite good.
No, you hired the master.
Precisely. It was that particular artist you contracted with because of their unique skill, their reputation. The law recognizes that the value was in the specific person.
Ah, okay. So it's about that irreplaceable element this specific person brings. That makes a lot of sense. What about the other side? Who is the performance supposed to be given to?
Usually, it should be made directly to the creditor, the person or the company who is owed the obligation. Simple enough.
Hmm.
However, the creditor can authorize someone else, a third party, to receive the performance on their behalf.
Okay.
The source uses another Latin term here, adjectus solutionis causa.
Okay.
All that means is someone who's authorized to receive the performance, but they don't have the right to demand it for themselves. Think of, say, your landlord's property manager collecting the rent.
Ah, right. They're just a collection agent, basically.
Exactly. They're acting as a designated receiver.
So if I owe a colleague money, they could say, actually, just give it to my partner instead.
Precisely. And if both you and your colleague agree on that, then you paying the partner is perfectly valid performance. Unless your colleague suddenly has a really good, legitimate reason to object. Maybe, things have gone sour between them and their partner, and they don't want them receiving the money anymore. That has to be a valid objection.
Got it. Okay. Now, where does all this performing actually happen?
Yeah.
Physically? Do contracts usually say?
Ideally, yes. A well-drafted contract should clearly state the place of performance. Makes life easier.
But they don't always.
No, they don't. And when it's not specified, the courts have to figure it out. They'll look at several things.
Like what?
Things like established customs or usual practices for that type of deal, where the contract was actually signed or agreed upon, if it's about goods, where are the goods located, and just the very nature of what's being done.
So let's go back to our furniture example. If I buy a sofa online and the contract is silent on delivery location, the fact it's a big physical item probably implies the place of performance is my house, my delivery address.
Exactly. That's a logical, practical inference the law would likely draw. It has to be delivered somewhere.
Okay. And finally, for performance, what about timing? When does it all need to happen? Is there always a deadline?
Well, the timing can be spelled out explicitly in the contract-specific dates, deadlines, timeframes, or it can be implied by the circumstances. If there's absolutely no agreement on time, either explicit or implied, the creditor can generally demand performance pretty much immediately.
Right away.
Well, immediately within reason. The law recognizes the debtor needs a reasonable amount of time to actually get things done. You can't demand delivery of 1,000 widgets 5 minutes after signing the contract if that's physically impossible.
Makes sense.
And the source also just gives a nod to the concept of mora debitoris, which is basically the legal term for the rules and consequences around unreasonable delay by the debtor, when they should have performed but haven't.
Okay, so performance, doing what you promised, properly and on time is the main way out. Got it. What's another route? The outline mentioned termination by agreement. That sounds pretty straightforward. Both sides just agree to call it quits.
It is fundamentally that, yes, but it can happen in a few different ways. The first couple mentioned are release and waivers. What's the difference there?
Good question. They sound similar.
Think of a release as getting a sort of get-out-of-jail-free card for your obligation.
Okay.
It's a formal agreement where the creditor frees the debtor from their duty, either completely or just partially, and it can cover debts you owe now or even ones that might arise in the future under the contract.
And it has to be agreement.
Yes. And the source notes that if it's only a partial release and it changes key terms of the original contract, it might need certain formalities to be valid.
Okay, so that's release. What about waivers?
A waiver is slightly different. It's more like the creditor saying, look, I know I have this specific right under our contract, maybe the right to charge interest on late payment, but I'm actively choosing not to enforce that right this time.
So it's intentional.
Very much so. It's intentionally giving up a known right or a remedy you're entitled to. And courts are actually quite careful here. They usually want clear proof that the party knew they had the right and deliberately decided to abandon it.
So just because someone takes ages to chase you for money doesn't automatically mean they've waived the debt.
Exactly. Just delaying enforcement isn't necessarily a waiver on its own. It could be evidence suggesting a waiver, but it's not conclusive. You need that clear intention to give up the right.
Right, okay. Inaction isn't the same as intentionally giving up a right.
Right
Got it.
here.
What about novation? That sounds new. Innovation.
You're spot on, actually. Novation is precisely that. It's when the parties agree to completely replace the existing obligation with a brand new one.
So the old one just disappears.
Completely. When novation happens, the original obligation is totally extinguished. It's like hitting delete on the old contract file and creating a fresh one.
Okay. What happens then to any related agreements? Like if someone had put up their house as security for the original debt.
Good point. Those are called accessory obligations, things like pledges, or maybe someone acting as a guarantor, suretyship.
Yeah.
The source explains that these generally get extinguished too if the main debt they were attached to is novated. Unless, and this is important, there's a specific agreement saying that the security or guarantee should carry over and apply to the new obligation. But the default is new debt, old security falls away.
Interesting. Wipes the slate clean, generally. Now, the source also mentions novation by delegation. What's the delegation bit mean?
That's just a specific kind of novation. It's where the key change is substituting a new debtor for the old one.
So someone else takes over the debt.
Exactly. But crucially, for this type of novation to work, you need the agreement of all three parties involved.
Yep.
The creditor, the one owed the money, the original debtor, the one getting out, and the new debtor, the one stepping in. Everyone has to be on board for that switch to be legally binding on the creditor.
Right. You can't just tell your lender, oh, by the way, Bob's paying my mortgage now, without the lender agreeing to accept Bob instead of you.
Precisely. Bob, you might agree, but the lender has to agree too.
Makes sense.
Well,
Okay. What about situations where people are arguing about the contract itself? The outline brings up compromise.
yeah, compromise is basically a settlement agreement. It's a way for parties who have a dispute or some uncertainty about their existing obligations to resolve it
How?
by creating a new agreement, the compromise that replaces whatever obligations they were arguing about.
So it ends the argument.
That's the goal. And the interesting thing about compromise is that the original debt or obligation doesn't even need to have been legally valid for the compromise to be effective. Yes. The whole point of a compromise is to settle the doubt, to end the dispute, and reach a final binding agreement to achieve certainty, regardless of the merits of the original claims. It's about moving forward.
Finding middle ground and getting closure.
Mm.
I like it. Okay, what about contracts that just run out of time?
That's what the source calls effluxion of time. Probably the simplest one.
How does it work?
If a contract clearly states it has a fixed duration, say a 1-year lease or a 2-year service agreement, it just automatically terminates when that period expires.
No need for anyone to do anything.
Usually not. It just ends. Clock runs out. Game over. However,
Uh-oh.
hey, well, just something to be aware of. The source reminds us about the Consumer Protection Act, specifically Section 14.2.
What does that do?
It puts limits on how long certain types of fixed-term consumer agreements can run for. Think gym memberships, cell phone contracts.
Those ones you can feel locked into.
Exactly. The Act often allows the relevant minister to set maximum periods for these agreements, preventing businesses from locking consumers in indefinitely. So there's a legal backstop there.
Good to know there are consumer protections in place. Okay, the last type of termination by agreement mentioned is notice.
Right. Many contracts will actually include specific clauses saying that one party, or maybe both, can end the agreement early simply by giving the other party a certain amount of notice, usually in writing.
Like a 30-day notice period in a rental agreement.
Exactly like that. But even if a contract doesn't have a fixed end date, maybe it's an ongoing service agreement with no specified duration,
Yeah.
there might still be what's called a tacit term, or an implied understanding that either party can terminate it by giving reasonable notice.
What counts as reasonable?
Well, that depends on the circumstances. But the principle is there. However, another however, the source points out, referencing some important court cases, that this right to terminate by notice, even if it's in the contract or implied, isn't absolute. Public policy can sometimes limit it.
How so?
If exercising the right to terminate, even with notice, would be really unfair or maybe unconscionable or go against broader public interests in that specific situation, a court might step in and say, no, you can't just terminate it like that. Fairness can override the pure contractual right sometimes.
So even if the contract seems clear, the broader context of fairness matters. That's a really key takeaway. Okay, so we've covered ending things by doing what you promised or by mutual agreement. What about when the law itself steps in and just says, it's over?
Right. This brings us to termination by operation of law. These are situations where specific legal rules or events automatically bring obligations to an end, sometimes whether the parties like it or not.
Okay. First one listed is set off. I think I've heard that term maybe in banking.
You probably have. It's essentially a legal mechanism for mutual cancellation of debts. If two parties owe each other money under certain conditions, those debts can automatically cancel each other out.
Automatically.
Yes, automatically, at least up to the amount of the smaller debt. But there are strict conditions.
What are they?
The source lists 4 key requirements. First, it has to be the same parties involved, acting in the same legal capacity, like both being principal debtors, not one acting as an agent, for example.
Okay.
Second, the debts must be of the same kind, which usually means both must be monetary debts. You can't usually set off a debt for money against an obligation to deliver a sheep.
Yep. Okay, fair enough.
Third, both debts must be currently due and legally enforceable. You can't set off a debt that's not payable yet.
Right.
And fourth, crucially, both debts must be liquidated.
Liquidated, meaning?
Meaning their exact amount is certain or can be easily calculated. You can't set off an estimated or disputed amount. It has to be a clear figure.
Got it. So same parties, same type of debt, both due, both amounts certain.
You've got it. And the source mentions a case, Standard Bank v. Eco Petroleum, which basically confirmed that set-off happens automatically by operation of law as soon as all those conditions are met.
So no need for the parties to even agree to it. If the conditions are met, poof, the debts reduce or disappear.
That's the principle, yes. It's a legal automatic cancellation mechanism designed for efficiency.
Wow. Okay, that's quite powerful. What's next? Merger. That sounds like companies joining forces.
It's a similar idea, but applied to obligations. Merger, in this legal context, happens when the roles of creditor and debtor for the same obligation effectively merge into one person.
How does that happen?
The classic example is inheritance. Imagine you owe your uncle 10,000 pounds. Sadly, your uncle passes away, and in his will, he leaves his entire estate, including all his assets and claims, to you.
Okay.
Suddenly, you are both the debtor, you owe the 10-pound K, and by inheriting the claim, you are also the creditor. The estate you now represent is owed the 10-pound. You can't owe money to yourself.
Oh, so the debt just extinguishes.
Exactly. It's extinguished by merger. The two opposing roles have merged into one person.
That's a neat, almost poetic way for a debt to vanish. Okay, what about when things go wrong after the contract is made? Like it becomes impossible to actually do what was promised.
Right. That's covered by supervening impossibility of performance.
Supervening, meaning it happens later.
Yes, after the contract is formed. If something happens that is completely outside the debtor's control and it makes fulfilling the obligation objectively impossible.
Objectively impossible.
Meaning no one could perform it. Not just that it's difficult or expensive for this particular debtor. Think, the specific unique thing to be delivered is destroyed in a natural disaster through no fault of the debtor.
Okay.
If that happens, and the impossibility is unavoidable and not the debtor's fault, the law generally says the obligation comes to an end.
Are there nuances?
Oh, definitely. The source points out the legal consequences can differ based on whether the impossibility is total or just partial, whether it's permanent or just temporary, and, importantly, whether the debtor was somehow at fault or responsible for the impossibility arising. So it's not always a simple get-out-of-jail-free card.
Right. So a bit of bad weather, delaying a delivery for a day probably doesn't count as supervening impossibility. It has to be something fundamental and unavoidable.
Generally, yes. Mere difficulty or increased cost usually isn't enough.
Okay. What about just the passage of time making a debt disappear? I see prescription mentioned.
Prescription is a really important legal concept. It's basically the legal process where debts or claims become unenforceable because too much time has passed.
Like a statute of limitations.
Exactly. That's another term for a similar idea. It's not that the debt technically disappears, but the right to legally enforce payment through the courts expires after a set period.
Why does the law do that?
It's about legal certainty. It prevents people from being faced with ancient claims where evidence might be lost, memories faded, and it's just unfair to pursue it after so long. It encourages people to enforce their rights reasonably promptly.
So there are different time limits.
Yes, the Prescription Act sets out different prescription periods for different types of debts, for example. Typically 3 years for many ordinary debts, but longer periods for things like mortgage bonds or judgment debts.
Can the clock be stopped or reset?
Yes. Certain actions can interrupt prescription. If the debtor clearly acknowledges the debt in writing or makes a part payment, or if the creditor starts legal proceedings, that usually restarts the clock.
Okay.
And certain circumstances can also delay the start or running of the prescription period, like if the creditor is a minor or insane, or if the debtor is outside the country.
And the source mentions the Makati v. Vodacom case.
Yes, that case was important because it helped clarify what types of rights are subject to prescription. The court basically said prescription applies to obligations to do something like pay money, deliver goods, provide a service. It doesn't necessarily apply to all legal rights, like, say, asserting ownership of something.
Interesting distinction. So it's a time limit on enforcing performance-based obligations. Okay, next up, under operation of law, insolvency. What happens to contracts when someone goes bankrupt?
Insolvency, being legally declared unable to pay your debts, has a huge impact on contracts.
I bet.
When someone is declared insolvent, a trustee for individuals or liquidator for companies is appointed. The Insolvency Act gives this trustee or liquidator significant powers.
Like what?
They have the power to look at the insolvent person's ongoing contracts and decide whether to continue with them if it benefits the creditors, or to terminate them.
Oh, they could just cancel contracts.
Right. In many cases, yes, or choose not to perform the insolvent party's side. Insolvency also generally prevents creditors from demanding specific performance. That is, forcing the insolvent party to actually perform the non-monetary part of a contract. Instead, creditors usually have to claim monetary damages from the insolvent estate, following specific procedures and ranking rules.
So it's a major disruption managed by the trustee for the benefit of all creditors.
Exactly. It's a structured legal process for dealing with financial collapse and its contractual fallout.
Okay, and the final one under operation of law is death. Does death automatically end all contracts?
Not necessarily. The general rule is actually that most contractual rights and obligations transfer to the deceased person's estate upon their death.
Meaning?
Meaning, the executor of the estate steps into the deceased's shoes. The executor can enforce the contracts the deceased was owed performance on, and equally, the estate is responsible for fulfilling the obligations the deceased had undertaken.
So the contract lives on?
Often, yes. But there are key exceptions.
Which are?
The big one is those personal obligations we talked about earlier, delectus personae. If the contract was specifically about the unique skills or identity of the person who died, like that artist or chef, then that obligation does die with them. It can't be performed by the estate.
Right. The estate can't paint the portrait.
Exactly. The other main exception is if the contract itself explicitly stated that the death of one of the parties would terminate the agreement.
So you can write that into a contract?
You can. So unless it's deeply personal or the contract says otherwise, death doesn't automatically end the obligation. It just shifts it to the estate.
Okay. So the show often must go on, even if one of the main actors has passed, legally speaking. Now, the outline just briefly touches on a couple more ways obligations end. Termination by cancellation due to breach, and termination by unilateral act in voidable contracts. These seem a bit different.
They are slightly different principles, yes. Termination by cancellation for breach is about one party's fault.
How so?
If one party commits a really serious breach of the contract, something fundamental, like completely failing to deliver the main goods, or refusing to make an agreed payment without justification.
A major screw-up.
Essentially, yes, a fundamental breach. Then the innocent party often gains the legal right to cancel the contract entirely.
And that ends it.
Yes. That act of cancellation terminates the remaining obligations for both sides, though the innocent party can still claim damages for the breach.
Okay, so that's fault-based. What about the unilateral act in voidable contracts?
This applies where the contract wasn't formed properly in the first place. Think situations involving misrepresentation, being lied to, duress, being forced or threatened, or undue influence, being improperly pressured.
Where the agreement wasn't freely made.
Exactly. In those situations, the law often considers the contract voidable, not automatically void, but the innocent party has the option to have it set aside.
They get to choose.
Yes. The innocent party can take a unilateral step, basically, declare they are setting aside the contract, and that action terminates the obligations under it. It's a remedy to undo a contract that was flawed from the beginning due to improper conduct.
Right, restoring the position before the flawed contract. Okay, wow, we've really covered a lot of ground there.
We have.
Termination by performance, then by agreement in its various forms: release, waiver, novation, compromise, time running out, notice.
Mm-hmm.
Then by operation of law, set off, merger, impossibility, prescription, insolvency, death.
Yep.
And finally, cancellation for breach and setting aside voidable contracts. That feels pretty comprehensive.
It really covers the main ways these legal ties get severed. And understanding these different mechanisms, it gives you a valuable framework, doesn't it, for looking at the whole life cycle of any agreement you might enter into.
It really does. For me, I think that automatic nature of set-off is still quite something. The idea that debts can just legally cancel each other out under the right conditions, almost silently.
It is efficient.
And also the nuances around when a third party can perform for someone else versus those delectus persona situations where it absolutely has to be the specific person.
Yeah.
That's fascinating.
Absolutely. And this isn't just abstract legal stuff, is it? Think about the agreements you listening encounter every single day.
Yeah, renting, phone contracts, buying stuff online.
Exactly. Which of these termination methods might realistically pop up in those everyday situations? Does knowing about these possibilities maybe change how you approach entering into those agreements?
That's a good question. The law gives us all these different ways for obligations to end. It really underlines that even agreements that feel solid and long-term, well, they have a defined lifespan, or at least multiple potential endpoints.
Mm-hmm. True.
What does that tell us about maybe the nature of commitment itself and change? Perhaps it just encourages us all to be a bit more mindful when we sign up for things, to understand not just the beginning, but also the potential endings.
It's definitely worth thinking about. Maybe you, our listener, could reflect on a contract you're in right now. Which of these termination routes might apply, or perhaps even offer a way forward if things aren't working out? Food for thought.